Good morning. Good morning. Good morning. This week's webinar is going to be about discovery. It's going to be about using discovery in order to win your case. And I wish I would have named this discovery. Stop doing what everybody else is doing and use your brain and think. But it wasn't such a catchy title, so I didn't use it. But I want to show y'all what my thought is for most things in life, and also for discovery in particular. This is a comment that I saw years ago and has always stuck with me. It's a Dilbert comment. Dilbert says, "Can you email the test data to me?" His coworker says, "We don't do it that way." And he says, "That's not a reason." She says, "We never give reasons." He starts screaming, "Nothing you say means anything." And she says, "That's how we've always done it." There are three ways to make me really upset at work. And one of them is to say, well, that's how I've always done it. That kills me. That kills me. So what I want to do today is encourage you to think about things on a case-by-case analysis, but also use the things you learn in different cases and hopefully the things that I've learned over the years to win your cases and get more money quicker during discovery. So I wish I could see hands when I ask this, but I'll imagine that you all are going to raise your hands. So my question here is, how many of you file a lawsuit, get in discovery and send written discovery, wait for answers, maybe send a 6.4B letter? That's the letter that you send according to Uniform Superior Court Rule 6.4B saying, hey, other side, your discovery stinks, your responses stink, send me good ones. Then once you do that for a couple back and forths, you then take the defendant's deposition, they take the plaintiff's deposition, you maybe take a fact witness or two, discovery closes, you then talk about mediating, and then you do expert depositions. To me, this is the classic, this is the way it's always been done, and I think it's nonsense. So what I want to suggest to you is that you can use discovery to do a couple of things, and you can do whatever the heck you want in whatever order, depending on the facts of your case and what makes sense. I've mentioned this before in a webinar. We have a case where we filed suit and immediately started taking for-trial video depositions of medical experts, of our clients treating medical providers. There's no rule against that. Why not? The whole idea of discovery, at least my take on discovery of why we're doing this, to me, it's not exactly to learn information. That's a byproduct of discovery. But I think the purpose of discovery is to create leverage so you can settle the case for more and you can settle the case quicker. So when I'm going through these strategies that I'm about to show you, I am looking to create leverage in order to increase the settlement value and get the money quicker. Do I then have to learn everything about the case and discover things? Absolutely. But my goal isn't to learn everything. My goal is to learn what's really important and use that information to my advantage or to keep myself out of trouble. And that's actually be the first thing that I'll talk to you about here. Using discovery to make sure that you don't commit malpractice, that you don't mess up, is probably the best way to use discovery so you don't do something wrong. I'm going to show y'all the classic 7, I call them the classic 7 interrogatories, requests for admission that we use in every case. Before one day this webinar gets used against me in a hearing or in a brief, I do not believe that requests for admissions are discovery. I'll say that again to any future defense lawyers. I do not believe that requests for admission are discovery. There is a difference between a request for admission and where you are asking the other side, do you agree to this or do you not? And discovery in my mind. Discovery is you're trying to find out facts or information. In request for admission, I'm trying to find out what your positions are. I think those are different. Judge Purdom, who has authored a treatise on this, on discovery in Georgia, He agrees with me / I agree with him. But I'll tell you, last week, a federal court judge told me I was wrong. So it goes both ways, but I just want to make sure that I'm not shooting myself in the foot here. I don't believe that requests for admission are discovery, but I'm going to group them in during this talk. So we send these 7 requests for admission in every single case, and they are truly just to make sure we didn't mess up. And I'll send you this list after the webinar, but I want to make sure that I have the correct people named, that I serve them properly, that I'm in the right venue, that personal jurisdiction, all that stuff. I want to make sure all that is okay. I also want to send a request for admission that says, do you contend that somebody else outside of these parties that are in the suit right now is responsible? And I want to make sure that I do that. I send that request before, I guess with enough time so that the response from the defendant is before the statute of limitation expires. You know, what I don't want to do is wait too long to send discovery and find out, oh no, we're going to blame this company over here, and then not be able to add that company in. So I always want to make sure that I send these 7 requests for admission and this 1 interrogatory at a minimum. That's going to keep me out of trouble. That's going to keep my insurance lower because I'm not going to make claims. And that's going to keep my clients happy because I'm going to be able to deliver for them. So I would suggest sending these in all of your cases, The reason you're sending those requests for admissions and that interrogatory is to make sure you don't do something wrong. But what I want to propose to you is that you do not need to send discovery in every case, besides those 7 interrogatories or 7 requests for admission and that 1 interrogatory. I've sat through so many depositions where the first 2 hours are the same interrogatories, that the same questions that were in the interrogatories, and it's a waste of time. Why are you asking where the witness grew up for the last 10 years when that's in the interrogatory responses? Why are you asking where the witness went to school when that's in the interrogatory responses? So I would suggest to you that you should do one or the other. You should either ask those questions in interrogatories and get written responses, or ask them live at a deposition. I see Warren Hines. Warren Hines is one of the best lawyers in town here, who helps lawyers stay out of trouble. If you have an ethical issue, if you have a malpractice issue, call Warren Hines. He's one of the best. And he said, "You're killing my business with this advice." I'm truly trying to keep everybody out of trouble here. I really am. But I see a lot of duplicative. That's a word. I think that's a word. Work through discovery, where people go do the same stuff over and over in different mediums and different forms. And I'll suggest to you, stop doing that. You're making your life harder. Stop doing that. So especially in federal court, where the interrogatory limit is 25, in state court it's 50. No limit on RPDs. You can send as many requests for production, and no limit on RFAs. I would really pare down what you send. So let's zoom out here. You have a new case and you're going to file it. You send the complaint, or you're drafting the complaint, and you say, am I going to send discovery with this? And that's the question I think you should ask. Should I send discovery? I am waiting for the case to not send any interrogatories, because I think there's cases out there that don't need them. I truly believe that. So I think the first thing you need to ask yourself is, why are you doing this? Why are you sending the discovery? And there's a few different reasons. And I'll suggest one of my reasons maybe you haven't thought of. The one reason everybody's thought of is because I need information. I need to find out things. The second reason is to work the other side. If I have a really good case that I think is just below the policy limits, but I'm trying to get it to the policy limits, it may be beneficial for me to educate the other side about my case, and do that through discovery. By sending them discovery, keying in on the important issues, and responding to discovery. I used to do something way back, 6 or 7 years ago with Jeb Butler and Darren Tobin when we all worked together. We made up something and we called it the Plaintiff's Statement of Discoverable Information, PSDI, Plaintiff's Statement of Discoverable Information. And when we used to file a case, we would send a plaintiff's statement of discoverable information out. And what it was we had a list of the top 20 or so interrogatories that are asked of our client. Where you live, where you grew up, who your family members are, all that background stuff. Where did you go to the doctor? I mean, you name it. We wrote it down on a list, and then we sent that with our complaint. So if I'm trying to educate the other side about my case, why not send them the answers to the top 20 most common interrogatories with your complaint? Plaintiff's Statement of Discoverable Information 1, plaintiff's name, never been married, no aliases. Plaintiff's Statement of Discoverable Information number 2, here are the addresses for the last 10 years. Number 3, where they've worked for the last 10 years, and so on, all the way down to pre-existing injuries, to what happened in the crash. And I'm clicking around, y'all can probably tell. I'm going to show you one. Here we go. I haven't looked at this since 2016, but let me share this with y'all. All right, so this is a case that I had. It was a car crash case against the city of Duluth. A police officer rear-ended our client. So here's our intro. We say to facilitate the just, speedy, and inexpensive resolution of this case, we are giving you a ton of information that we don't have to. And here it is. Statement number 1. Here's the basic information, and we included a ton of stuff. You see name, address, cell phone provider, birthday. We don't give social security numbers. No reason to. It's a made-up government-issued ID number, just like a library card. You don't have to give a social security number until after the settlement. Number 2, here's the residence for the past 10 years. Number 3, here's the educational background, employment history. And we can go through this whole thing. Prior lawsuits, criminal background. Y'all see where I'm going. I'm going to the top interrogatories that I know I'm going to be asked. Here's the collision down at the bottom here. I'll even tell you about the collision and what happened. So if you're trying to educate the other side, just give them the information. And you can make up something like this and you can just serve it and say, here's our discoverable statement. Don't send me interrogatories. If we used to get interrogatories, then we'd say, see statement 1, see statement 9, see statement 6. I think our record was like 13 in a row where we got them correct. We were able to say, see statement 1, 2, 3, 4, all the way down to 13. So you can be offensive with discoverable information and just give it to them. It also puts you in an amazing position with a judge if there's ever a discovery issue. Imagine if you have to file a motion to compel. What's your lead into that motion to compel? Well, Judge, we gave them all our discoverable information with the complaint before they ever even asked. And now they won't tell us this thing that we need to know. So it puts you in a really good spot to have the moral authority in any sort of discovery issue. Now, let me tell you, this is what I think is the part maybe you've never thought of. Here's the opposite side of that coin. I think there are many cases that you should not send discovery, or you should send very minimal discovery to not make the other lawyer work. Why would I not want to make the other lawyer work? Well, I don't have many of these cases. I don't think we have any. But these Allstate cases, I keep hearing that Allstate won't do this, Allstate won't do that. They're making us try everything. Okay, well, why make them spend time on your case if you know you're going to have to try it? Why not do the bare minimum outwardly? That's the key word here. I'm not saying do the bare minimum on the case. Why not do the bare minimum outwardly, where you're only sending them the very minimal interrogatories, the very minimal RPDs, the very minimal RFAs. And that makes them not talk to their client as much. You know, I hear a lot of lawyers say, oh, I can tell by the discovery response that they haven't talked to the client. that meaning the defense lawyer hasn't talked to the defendant. That seems great to me. That means that I have a fresh crack at that witness during a deposition. And there are a lot of cases, I think, that you can put defense lawyers in a really bad spot by sitting quietly, outwardly, doing all you can do behind the scenes, talking to doctors, getting statements from witnesses, doing everything you need to do, but not telling the other side, hey, I'm working my ass off on this case and I'm killing it. What you do is the day after discovery expires, you send them a nice letter that says, hey, while you sat on your hands, this is all the stuff I did. You are screwed. You are screwed. I think that's one overlooked way, especially to me, especially if I have a good lawyer on the other side. If I have a really good defense lawyer, I don't want to make them interested. I don't. You know, the best way to get me interested on a case is send me a 6.4 letter, because I know that our discovery responses are complete. I know that they are not full of objections. We object very rarely. So when you send me a 6.4 letter or send me some snotty email or something, that just makes me interested. That gives me motivation to now talk with you and now work the crap out of the case and bury you. So I know there are defense lawyers who think the same way, especially the really good ones. So I think if you have a really good defense lawyer, you don't want them to dive in to your case and dig into a position and know all the facts, at least yet. And if you have somebody who's maybe overworked, an in-house insurance lawyer who is just getting by, doesn't really care, why make that person care about your case? I don't see much benefit. So I think that you should consider two separate ends of the spectrum, which is one, I want to get this case settled. I'm going to work you to death. You defense lawyer who doesn't want to work, I'm going to work you to death. And you're going to say, uncle, I'm pounding the table here. You're going to say, uncle, and you're going to pay me, because then I will go away. And there's a few lawyers right now that I have cases with. I send them an email and sometimes the response is something like, man, another email? I'm like, yeah, I'm going to send you one tomorrow. I'm going to send you one the next day. I'll send you some more discovery. I'm going to ask you for more depos until you say uncle. On the other end of the spectrum, I have defense lawyers that I don't want to talk to. I'm not calling you. When you email me, I'm not writing back. I'll tell you a master strategy. There's no rule you have to write back to people's emails. So don't. Let them forget about it. So big picture, I want you all to think about, should you be working the case outwardly or should you not? Because that is a strategy decision up front that will change the perspective and your approach of how you do things. So we talked about staying out of trouble. Let's talk about using the other side's using discovery to get the other side's get the other side's position on things. So I'll show you an answer here. Let's look. We'll just pick a random case that I have. I'm looking at my list. This one's a good one. So I think that the starting point to figuring out what the other side did or is doing or thinks, wants to do, is to look at their answer. And in this answer, which I got pulled up here, what I don't see, interestingly, at the top are any affirmative defenses. But here at the bottom, I would say most answers lead with the affirmative defenses. I am starting with the affirmative defenses. So first one, fails to state a claim, says it all the time. Second one though, this is a big one. Plaintiff was negligent. Well, I'll tell you in this case specifically, my client was a passenger in a car. Anybody see a problem with that? My plaintiff didn't do anything wrong. So what I'm doing when I go through the answer is I'm making a note. That's important to me. I can use that to my advantage. So am I sending an interrogatory that asks, why the heck did you say that? Think about what that makes the defense lawyer do. It makes the defense lawyer think, say, oh, okay, let me go talk to the client, make sure, thinks about the case. So if I want them to think about the case, I might send the interrogatory. If I don't, if I want to surprise the defendant, I'm putting the answer in front of them and saying, this is your answer. sit in your lawyer's answer. This is your answer. Why'd you say this? Why do you think the passenger in a car was wrong when you hit them? What's the deal? So I'm going through all of these answers, and these are maybe the most important topic in my deposition of the defendant. I want to know all of the answers. Now, sometimes I won't bring it up in the deposition because I want to wait until trial. We did this recently where I handed the answer to the defendant. This was right after opening statements. The defense gets up and says, "This was our fault. We're so sorry." You know, they can't say sorry, but this was our fault. We take full responsibility. We want to make it better. Well, I show them the answer. The first witness I call is the defendant. And I say, "Hey, I heard your lawyer say this. Are you taking full responsibility?" "Yeah, I always have. This has always been my fault." Well, you know, in this legal document, this answer that you never updated and that we've been relying on for 2 years, you say that it was also my client's fault. You don't think that though, right? "No, I don't." Well, what the heck? Why'd you put it in there? And what you're showing to the jury eventually is that it's either a lawyer game or that the witness is now, you know, pretending to be genuine. The next thing that I want to show you is some interrogatories that you can use to find out what the contentions are of the defendant. So, do you contend that the plaintiff assumed the risk of injury? Does the defendant have any opinion as to the cause of the crash? Here's my favorite one, and I'm going to spend a little bit of time on this one. Do you contend that the plaintiff is faking their injury? That they're lying, they're not really hurt, they're exaggerating, whatever word you want to use. So those are 3 interrogatories that I'm asking in every case to find out what the other side thinks. One thing that comes up in a lot of my cases, and I imagine a lot of yours, is that the defense says that your client has a pre-existing injury, or they're not really hurt like they say they're hurt, or that they're exaggerating, whatever it is. You know, that whole kind of chain of thinking, which is they put in every defense, it seems like. I always want to make sure I ask the defendant during their deposition, "You know anything about my client, right? You know anything about their injuries? You know anything about her work history? You know anything about her doctor's visits? You know anything about her treatment? You know anything about anything?" Because that, again, makes it a lawyer game, which I think helps me. Another thing that you can do, and we do on a consistent basis, and it's a lot of time, but it's worth it, is this. So these were filed in February of this year. So you can see we're really doing this. All right. Our client's name is Aisha. Aisha was driving down the road and she gets hit by Christopher. What I'm trying to do, my goal here and what I'm about to show you, is to be offensive and box the other side into a position that either they're going to say, "My client was injured," and they agree, which they're not going to agree. "My client was not injured," which I'm okay with because I'll show you what I do, or they don't know. To me, they don't know is as good as your client isn't injured, or excuse me, as your client is injured. Because if they don't know, it really limits them at trial to then come into court and say, "Oh yeah, totally not hurt." You're like, "But you said you didn't know. What has changed?" So here's what we do. We start with the very simple premise that our client was injured and that they have no evidence showing our client was not injured. So that's the premise. And you're going to see this repeatable pattern. The next thing we go through is you have all of these medical records and imaging. We go through all the providers. So you can see all the records all the way down to number 10. So what we're doing here is we're starting with this premise. Our client was injured. You don't have any information to the contrary. Now, you have all of these records. So that way, if they say, "We don't know, we don't have enough information," we've already hedged our argument by saying, "Yeah, you do. You have everything." And here comes the pattern. On the day of the crash, our client complained of neck pain. When she complained of neck pain, she was experiencing neck pain. You have no evidence that when she complained of neck pain, she was not experiencing neck pain. We will do this with every single complaint through the whole case. And I literally mean through the whole case. Let's just show you all big picture. These are pages of this. Give you another example here. On May 6, 2019, our client had a discectomy with a decompression and so on. You have no evidence that they were not medically necessary. Now, if they say, yes, we do have evidence that they were not medically necessary, I then send an interrogatory and say, tell me all of your evidence. Tell me everything. And this pattern, like I said, is repeated. Client complained of this. Client was actually having whatever the client complained of. You don't have any evidence to the contrary. And then if you do, the follow-up is the interrogatory to find out exactly what it is. Then you get to kind of back to big picture stuff. She has not exaggerated her pain. No evidence that she has exaggerated pain. She has not lied. No evidence that she has lied. Not lied to her doctors. And we're making it impossible for them to be in the middle. That is one of my primary goals of discovery. I want to make the other side take a position. Sometimes and for the most part, I'm happy just to get a position. As long as the other side gives me a position, are you going to say X or are you going to say Y? Then I've done my job, because I can evaluate the merits of X and Y and see and strategize about what I do if they say X, what do I do if they say Y. What I can't do is I can't prepare if I don't know if it's X or Y. So if they're not going to take a position and I'm not forcing them to take a position, then I can't do my job. So I think, and I did this for a long time, and I see it with a lot of lawyers, and I'm not saying I know everything by any stretch. I see this because, with 4 lawyers in our office, we work on a good number of cases and we overanalyze them, which I'm fine to do. But I would say almost everybody says, or everybody out there spends too much time on the crash or whatever it is, the negligent act. If there's a car crash, you should be able to figure that out. If there's a whatever that happened, a fall, you should be able to figure out who's at fault. Or at least you should be able to figure out how the percentages of fault are probably going to be weighed, who could be responsible, what a jury could do on one hand, what could they do on the other, and you can find a range that should make you feel comfortable. I think what we as personal injury lawyers don't spend enough time on is damages and causation. So for causation, I want to know, is that an issue? And I want to know what is the support for the defense position that there is no causation. And I want to make them articulate that position. And I want to make them do it early on. If their position changes down the line, and they say, oh no, now we don't think there's causation, or now we do, whatever it is, I'm asking the golden question, which is, what has changed? What have you learned between when you said this in a request for admission and trial? What's changed? And I bet the answer is nothing. Or they actually sat down and thought about the case and now are trying to, come up with another theory to win the case. Brad Valentine asked a good question here. He said, I would assume the defense just says they lack info on all those RFAs, made a reasonable inquiry, but cannot admit or deny. And that is a very common response. So if you think about the process, it's one, the client on this date, the client complained to her doctors this. Well, I think they have to admit or deny that because they have the medical records. So if they did a reasonable inquiry and they look at the records, they'll see the client said that. Now I have one case I know of that I can think of where the defense says, we don't know, but that's what the records say. Hey, I'm good with that. That's awesome. That means the records say it, you don't know, so let's believe the records. We'll believe the doctor. The next one, when the client complained to the doctor on that date of that pain, so When the client told the doctor on May 6th that she was having neck pain, she really was having neck pain. Well, almost all the time, the answer is, we don't know. After reasonable inquiry to the facts available to us, we cannot admit or deny. That's great. I'm good with that answer. Because if you don't know, the only thing that can change is you learn something new. So if I'm sending these requests for admission after my client's deposition, after everybody has all the medical records, what else is there? What else could they need? So if they come to court and say, oh no, she was lying on May 6th, she wasn't really in pain. Based on what? What changed between when you answered this RFA that said, we don't know, and what you're saying now? What did you learn that was new? And I bet you the answer is nothing. And then the third thing is you don't have any information or any evidence that shows that the client was not in pain. That's the third part of the sequence. Complained of pain, was in pain. You don't have evidence that she was not in pain. And I get a lot of, we don't know. Well, I've filed motion compels on that issue. And it's not, I say motion compel because RFAs are not discovery. It's not a motion to compel, it's a motion to determine the sufficiencies of requests for admission. It's totally different procedure, totally different statute. I'll send you one if you want. I'll actually send one on this issue. And when I get an I don't know if you have evidence, shit, you need to look. You need to look and figure out what the answer is. Do you have the evidence or you don't? And that's not, I don't think that invades the mental impressions of counsel. A judge has never agreed with that position. I'm not going in your mind. I'm saying, do you have evidence? Do you or do you not? Danny Nagel asked if I send RFAs twice. I will send them every 30 days from the time that discovery is over until trial. Has your position changed? Has your position changed? Has your position changed? So I will just keep sending them. And there's nothing wrong with that. There's nothing wrong with that. Do you really need to send them every 30 days? Probably not, but sending them every 90 days to see if something has changed, I think that's well worth it. I mean, what's the cost, the manpower involved in copying and pasting some RFAs? It's very, 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 very little. And the risk is zero. And the reward is high because, there may be a change in one of those answers and then you can figure out why. Always before trial, I'm using requests for admissions to ask the other side. And this is what we tried to do in federal court a couple of weeks ago and got shut down, but I'm still going to keep doing it because I think it's a judgment call by the judge at a minimum. I'm always asking, do you admit that you were negligent? Was anybody else negligent? Or putting these in RFA forms. So that way I know what they're going to say when they come to an opening statement. I don't want to be surprised when they stand up and say, we're admitting we were at fault. That's great, maybe, but I want to know that beforehand. So I can adjust accordingly up front. So those requests for admissions require a few things. They require you to know your client's medical history. They require you to identify what's important in the history and in the complaints and what you're going to focus on. But this is all stuff you should be doing anyway. So I think you can be really efficient with creating these RFAs because the first time you go through the medical records, create the RFAs as you do them, even if you're not going to send them for 9 months. The same thing with 6.4B letters. When you get discovery, I think the natural habit is I'm going to open it up on the computer or wherever, I'm going to read them, and I'm just going to read them and see. And if I do that, by the time I get to interrogatory 12 or RPD 15, I'm angry because I'm like, this is bullshit. They're not even answering the questions. This is crap. Well, what I would suggest you should do, and what I've trained myself to do, is I will not just open up discovery and read them. I will open up discovery on one. I've got 2 screens here. 1, 2. I will open up discovery on one screen, the responses, and on the other screen, I'll open up an email. And I will just start drafting the 6.4 letter the first time I go through discovery. There's no reason to duplicate your efforts by reading the discovery, then reading it again to go through the 6.4 letter and decide what you're going to include. So do it all in one fell swoop. So when you're reading the medical records, start thinking, am I going to send RFAs and what complaints am I going to list? And you're also making an outline of your client's medical history. If you use a nurse, have the nurse tell the nurse what your plan is. So that way the chronology can reflect what you need. And if you're going through discovery, do it with the purpose of, I'm going to go through every question, every interrogatory, every RPD, and I'm going to ask myself, did I get the information I needed? And then at that exact moment, I'm going to write it into we use an email. We're not fancy. So we send it into an email and it says, here's the responses we got. And I'm doing all that in one action. And it's saved us a tremendous amount of time. But remember, 6.4B letters, if you get crappy responses from the defense lawyers, 6.4B letters make the defense go and work. You're telling the defense your answers suck. Go tell me the right information. Well, they have to typically go and do work to do that. So a lot of times when we see bad responses, I think that's an indicator of the lawyer not caring about the case, which could be good, could be bad. But I want to analyze that and think about what the strategy is. Should I make them work or should I not? Now, of course, there are things that you just have to follow up with, things you have to know. So sometimes you have to send that 6.4B letter. And when you do, think about whether you want to go balls to the wall and list 90 things that they've messed up on, or you want to focus on the 5. But that's a strategy call you should think about, because I think the act of doing work, or at least the act of outwardly doing work, that is a decision you need to make to show the other side that you are going to work and that they should work. Sometimes you don't want to do that. I also want to show you, I mentioned the RFAs that we send leading up to a trial to confirm, if the judge allows us, to confirm the positions. So let me show you these. These aren't about damages. These are about liability. So our client's name is Musa Quay. And Musa's driving down the road. This is actually the second case I've had like this. One tried it to a jury verdict and got a great result. But Musa's driving down the road and he smashes into, at full speed almost, he braked for a while, but he was motoring, smashes into a tractor trailer that is stopped on the highway, right in the travel lane. So the other side says it's Musa's fault. I can understand that. Our guy hit a tractor trailer that was stopped in the middle of the highway. Now, I can get into the weeds with you in this case. I won't, but tractor trailers shouldn't be stopped in the highway. And if they are, you should have flares, cones, or triangles out. So that way, if you're approaching a truck that's stopped in the middle of the damn highway, you will run over something before you hit the truck. If you're driving down the road and you run over a triangle, you're going to know. And this, when I say get in the weeds, this goes into perception and reaction and reasonable expectations that vehicles are moving on the road and all this stuff. But we want to limit the reasons that they can say Musa was at fault. So we've brought up the idea of a cell phone, and we're asking them, do you know anything about Musa being on or not on the cell phone? You know he had a cell phone. We know he had a cell phone. But I want you to say your positions right now. So we're asking all this. And then we get into just the distraction. You have no evidence that he was distracted. You have no evidence that he was under the influence of drug and alcohol. Drugs and alcohol are not an issue in this case. Musa doesn't drink. But we want to get that issue up front, get it answered, and then eliminate it. And then I can go to the jury and say, remember, you can read requests for admissions. You stand up and you read them to the jury. So if they answer these and say, no, we have no evidence that he was touching his cell phone, which they don't, then you read that and say, the defense has no evidence that Musa was touching his cell phone while he was driving. And then if they try to say that, try to insinuate or somehow argue that he must have been distracted, he must have been on his phone, who knows? They can't. So I guess another global thought here is don't run from issues. Discovery is the time to identify the issues and find out, is it X or is it Y? Burying your head in the sand because, that could be bad for me. Or I might not like their response. That could hurt my case. I don't look at it that way. The only thing that can hurt your case is not knowing the answer. Your case is your case. I always struggle with wondering how much a lawyer matters in a case. I think the answer is significantly, but I don't know really to what degree, because there's a lot of things lawyers can do. I say this in mediations. I'm zoning into my mediation opening statement, but I say this all the time, which is there's a lot of things lawyers can do. The one thing we can't do is change the facts. We can argue the facts, we can spin the facts, but we can't change the facts. And if the facts are undisputed, if the facts are obvious, the case should go one way or another. You either should win or you should lose. If you should win, then you should be spending more time on the damages component, so that way you get the number that you want. Got a question about how to read the RFAs to the jury. If you've watched any of my webinars, my belief is the courtroom is mine. It's not the judge's courtroom. I'm the plaintiff. I represent the plaintiff. I'm the one who has to bring the case. I have to meet the elements. I get to stand up and speak first in everything that we do. It's my courtroom. So to answer the how do you read the RFAs, I grab the RFAs and I stand up and I turn to the jury and I say, ladies and gentlemen, there's things called requests for admissions. These are requests that you make. They're statements. And the other side can either say, we agree with the statement, we disagree with the statement, or we don't know. We sent statements to the defendant and we asked them, do you admit that this is true? Do you deny and say it's untrue? Or do you say you don't know? I now want to read to you certain requests for admission. If the judge lets you, I would keep going and say, these are stipulated as true. So the defense cannot change their position. Here they go. Now, can you get away with all that? Depends on the judge. If you want to be safe, if you want to be careful, I think you bring up to the judge before you do it and say, Your Honor, I'm going to do this. Would you please instruct the jury what the hell an RFA is and what it means, so you can rely on the judge? I like to do it myself because, again, if you've watched any of these webinars or just know me, I want to be the expert in the room, even if I'm not, because I'm not. The judge is the expert in the room. But I want to appear to the jury to be the one in charge. That way they can rely on me. So to answer the question, I either just stand up, explain, and read, or I tell the judge, I'm going to do this. Please instruct the jurors, and then I'll stand up and read. And I do that outside the presence of the jury. I think when you read RFAs to a jury is really important. I like to do it in one of two ways. I like to have their statement first. So this is the RFA and this is what they say. They say the answer to this question is yes. And then immediately I'll call a witness who says the answer is no, one of their witnesses. And it's like, what's going on? Why do you say that yes, but then you say no? Or I'll get a witness who says no, and then I'll read the RFA that the answer is yes. I'm trying to create chaos isn't the right word. I'm trying to create conflict. I think that jurors award a lot of money in three circumstances. One, the injuries are terrible. I mean, that's the easy one. Two, the jury gets upset with the conduct of the defendant. Three, the third one is that the jury really, really likes the plaintiff, which I think is the hardest one, because I think human nature is to blame people who are injured and say, well, that wouldn't have been me. I wouldn't have done that. In this crash where Musa crashed into the car, I think the natural jury response is, well, I wouldn't have done that. So I believe that the best ways to get a large verdict is you have to have the injuries, but also to make the jury care. And I generally think that anger, this is voting. This is get out the vote 101. Y'all see how not to go into this. I did work at a cable news station, so I feel like I can say this as an authority of some kind as opposed to an opinion. But, news stations use immediacy. They use importance, and they also use urgency by scaring you to make you watch TV. Political parties do that to get you to vote. To some degree, lawyers can do that with jurors. Now, do I think you should scare the crap out of jurors? No. But I think that if the jurors have a reasonable, if there's a reasonable, I guess if there's a reason why the jury should be mad, or why the jurors should be mad at a party, I think you should give the jurors that information so that way they can consider that. It's one reason we don't claim punitive damages a lot, because if I hit a high number, I want that built into compensatory damages, not in punitives. I don't want it capped. So if the jury's going to get really mad at the defense because they're lying and doing bad stuff, I want that built in the compensatory damages, and there's no cap on it. And there's no taxes for my clients there's taxes on punitives, and punitives are capped. But let me get back to discovery real quick. Hopefully that answered your question. The last thing I want to talk to you about are depositions, and I'm not going to go too deep here, but there's one in particular I want to talk about, and that is the 30B6 deposition. I view the 30B6 deposition as a for-trial cross-examination. I do not view it as a discovery tool. The history of the 30B6 deposition was that if 10 people in a company had all the information you needed, at least parts of it, so you would have to typically go to 10 people to find out the 10 things you want to know. You're able to send one notice for a deposition and have a company representative come, maybe even 10 company representatives. You can do it all at one time. The downside of a 30B6 deposition to me is you have to tell the topics. You have to tell the other side, here's my outline. Here are the topics I'm going to cover. Our rule with depositions is if you're living and breathing, I'm going to depose you. So if you're living and breathing, I'm going to depose you. I should be able to depose everybody without a 30B6 and find out what I want to know. Now remember, or think about this, there is a provision, it's 911 30B1, 30B1, that allows you to identify a person by title, by role, by responsibility within a company. So you can say, I want to depose the safety director. I want to depose the supervisor of the defendant. I want to depose the whoever. You just have to sufficiently identify who that person is by their job duties, titles, roles, responsibility, whatever. So you can do that. And you can find out all of the information you want to know the longer way, meaning through depositions. And then the 30B6 deposition, I think, should always be videotaped, and it should be a cross-examination, because you can play the 30B6 deposition, because a 30B6 witness, no matter what, is an unavailable witness. A 30B6 witness is an unavailable witness. So if you get an amazing cross-examination, then you can play the video. Or you can ask the same questions again at trial and get the same answers, and maybe even impeach if they don't give you the same answers. So you have two options there. One story that sticks out in my mind is I was deposing a bunch of witnesses, defense employees that worked in an apartment complex. We deposed all of the maintenance people, all of the leasing agents, the owners, everybody. And these depositions were extremely long because there was a lot of information to cover. So we did all these, and then a month later, we noticed a 30B6 deposition on, and I kid you not, this deposition topic list was like 6 pages. I don't really want 6 pages. Fun fact. I don't care about 6 pages. I wasn't going to ask all those topics, but I want the person who's available for those topics. So what I'm doing, what I did was I masked what I was trying to do. So I take these really long depositions a month earlier, and I get all the information I need. Then for the next month, I am writing true cross-examinations, and that's what I'm going to cover next week. This is my lead-in to next week. So I'm writing cross-examination questions, and I'm making it as tight as possible. I'll go through the process with you next week. Then I get to the 30B6, and it's the owner of the company who I had spent literally the full 8 hours with in deposition testimony a month ago. And he sits down and he's thinking this is going to be another, long thing. He's got bottles of water. He had a snack bar. He had everything to be prepared for a long one. And I go in and I think it was 8 minutes. I do an 8-minute cross. Boom, 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 boom. And I've got documents supporting it and I'm impeaching him left and right. And I get the hell out of there and I stop. That won me the case. That won the case. And the reason was because they thought that that was discovery, that this was a discovery deposition. There's no such thing as a discovery deposition. Every single deposition you take may and can be used in trial under certain circumstances, whether that's the witness lives outside of the county in state court, whether that's the witness lives more than 100 miles away in federal court. The witness passes away. The witness doesn't show up with a valid subpoena. So every deposition you take, you need to do the discovery part, get the information that you need, and then soundbite. And when I say soundbite is you're going to ask about whatever topic. You're going to ask the defendant in a car case, what did you do before the crash? Well, I was at work. I went to my car, drove to McDonald's. I started eating the McDonald's, and then I crashed into you. And you learn that all through different questions. Where were you working? What McDonald's did you go to? And these are all open-ended questions. And then you want to soundbite that. And a soundbite is kind of what I just did. Take the information and put it in very small sound bites. Say to the witness, I want to make sure that I understand what you just told me. You were at work. You left work and went to McDonald's, right? You got food. You made a left turn out of the parking lot. You went to the light. When you came through the light, you're still eating your McDonald's. The light's yellow. You try to make a left turn, and the car that had the right of way in front of you hit you. There you go. So I've just taken probably 3 pages of deposition testimony, and I've made it 3 questions. Now I have the soundbite. Now later, if I have to use that because the witness is unavailable for whatever reason, I'm not showing the 3 pages. I'm clipping and just to the soundbite. So use discovery with an eye towards finding out information, but more importantly, getting back to the first thing I think I said, getting the case resolved as quickly as possible and for as much money as possible. And the way you do that is by scoring points. You're scoring points, and you need to score points with your discovery. So I would suggest to you, it's kind of like football. When you first file a case, it's like a kickoff. Now I'm playing defense. I send my request for admissions, and I'm making sure in my interrogatory that I showed you all, asking, is anyone else at fault? I'm playing defense. I'm making sure that I didn't mess something up, trying to win field position, if you will. Then at some point during discovery, I'm going to switch. They're going to punt to me, and now it's my turn. And I can decide a few things. I can decide to run a play or not. If I decide not to run a play, what I'm doing is I'm up in the coach's box, and I'm strategizing. I'm doing all this stuff so that when I do run a play, they're totally at a loss and don't know what to do. And that might be even after discovery. But usually I am running a play. I'm going offensive, and I'm going to do things to make points, to make my case more valuable. And in doing so, to get it settled quicker. You know, I'd rather take $20 today than $22 in 2 years. So, I mean, time is very important, the time value of money. So use discovery to box the defense into certain positions. Are they going X or are they going Y? And if they don't know, why don't they know? Make them either pick or make them say, I'm never going to pick. That's a choice in and of itself. We're never going to pick an answer. And once you know X and Y, then you can go forward with your case. You can make decisions based on what the defense is going to do, and then you can be offensive. All right. So in a recap, there is no one size fits all. You can't have standard discovery to send in every single case. You just can't. I think there are cases that you should overwork because that will help win the case. And I say overwork, I mean, do everything in your power through the discovery process. And there are other cases where you should limit your outward, I don't know how many times I've said the word outward during this webinar, but limit what the defense sees that you're doing to catch them off guard, I think that discovery is something that can be made extremely efficient if you have a purpose in mind. So as you're going through discovery responses, have your Word document or email up and draft that 6.4B letter as you go through it. But before you hit send on the 6.4B, before you send it, ask yourself, is this worth it? Should I do that? Do I really need to send this? Do I want to make them work? And also, you can be really efficient with your medical records and how that's going to dovetail in with requests for admissions that I would suggest you send later to limit the issues and narrow the scope at trial. These are my general thoughts on discovery. I hope this has been helpful. I would suggest that everybody needs to sit back and really think about what works in your case. Hopefully some of these ideas will help you. There are things that we incorporate in our cases. There are other times that we don't incorporate them for a lot of reasons. I appreciate y'all joining me. I had a good time talking about discovery today. Next week, we're going to talk about cross-examination. I'll show you how to gather the information, how to draft your questions. I say it questions because I'm going to tell you don't draft questions, but I'll tell you how to draft your outline or your bullets for a cross-examination, and then I'll show you how to actually execute that. We'll do some back and forth with a pretend witness, and I'll show you some strategies of how to be very persuasive with your questions and with the way you present to the jury while you're doing that. So I appreciate y'all joining me. Thank you very, 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 very much this week. Next week, again, cross-examination. And the week after that, we'll take a break for 4th of July. And we'll come back and maybe the world will be closer to turning on. I don't know. And I look forward to seeing y'all. So thank you.